We're back as the jury in Donald Trump's hush money trial has finished its very first day of deliberation. You can see there 4 hours and 37 minutes. It's up there right there. Today they requested to rehear 4 parts of testimony, 3 from American Media Incorporated tabloid magnate David Pecker and 1 from Michael Cohen. And the lawyers are still in the room even though the jurors have gone home, and the lawyers are deciding exactly which part of the testimonies will be read back tomorrow. They're going back and forth, agreeing, disagreeing. Joining us now to discuss, retired Judge LaDoris Hazard Cordell. She's also the author of the book, Her Honor, My Life on the Bench, What Works, What's Broken, and How to Change It. So, Judge, the jury also requested to rehear the instructions that they heard this morning from Judge Merchan, more than an hour's worth of instructions. I think it's also the policy in California that you don't give paper copies of the instructions. Maybe I'm wrong, but it doesn't make any sense to me.
Well, Jake, first, thank you for having me on. I'm sitting here listening to CNN today and the reports from the court and just shaking my head. Shaking my head for, number one, the jury instructions. In California, it's discretionary. A judge can give copies of the instructions to the jurors. I always did that, every jury trial, and I presided over a lot of them in the nearly 20 years I was on the bench. Give them the jury instructions. So I read through, actually skimmed through the jury instructions that Judge Merchan read to the jurors. The reasonable doubt instruction alone is 1.5 pages. I mean, it's just absurd to me. So that's one. And then the transcript. Why are not transcripts digitized? So when they're gone through, you digitize them, and then they can provide copies of the particular excerpts that the jurors want to hear. Instead, they have to go through, and that's tedious, I get it. Both sides, the judge, they go through to find out exactly what the jurors want to hear from the transcripts, and then they should provide it to them. Instead, they're going to sit there and it will be read. Now, it is read back. Transcripts are read back in courts in California. And there's also a move toward digitizing things so the jurors can not just hear it because the person who reads it can't use any affect at all. Give it to them in writing, printing so they can read it. I just don't get it. The courts in New York are not of the 21st century, and something really needs to be done about this.
You're being polite. They're barely of the 20th century, frankly. Judge Merchan instructed the jury that they must set aside any personal opinions or bias in favor of or against Donald Trump. Are jurors able to do that?
Every human being has bias. And I will tell you from my time presiding over jury trials, jurors really, really want to do the right thing and follow the instructions in most cases. They really do. So they'll work really hard to say, you know what, it doesn't matter what this man stands for, what we think this man, portends. We will just look at the instructions and come up with the facts. You know, the fact that they have requested testimony now means that there is disagreement in the jury room over what was said by these individuals. So to clear it up, you get the transcript in so they can all be on the same page. So that's what it signifies when they want to have stuff read back. Some will say, well, no, he didn't say that. Well, I think he did. Well, we need to get the transcript in. So clearly they're having some discussion and likely disagreement about their perceptions of what they believe they heard during the testimony. So that's fine. That's what they're supposed to do. You know, there have been some predictions, Jacob. Go ahead.
No, you, please.
There have been some predictions about the length of deliberations. And it's anyone who says, yeah, I can predict, it's like reading tea leaves or you're on crack or something, because you can't do that. But one thing I can tell you definitely about the length of jury deliberations, they will be longer than the shortest deliberations on record, and they will be shorter than the longest. The shortest deliberation on record was in 2004, where a jury heard testimony about this person who was charged with cultivating 23 marijuana plants. The jury went in the deliberations room and came out after 60 seconds. That is the shortest jury deliberation, and they acquitted. The longest, and that was in New Zealand, the longest is in the 1990s in LA, in federal court, where there was a 6-month jury trial. The jury deliberated 4.5 months. So I can tell you it will be longer than the 60 seconds, and it'll be shorter than the 4.5 months. That's about all we can say about jury deliberations.
Do you know anything more about the 4.5 month one? Why it took so long, or did they at least emerge with a verdict?
Oh, absolutely. So this was a civil case, and it was a mother and a son suing the city of Long Beach, California, in federal court. And this went on for 4.5 months because, and some of the jurors just quit. They said, we're out of here. We're just not going to do this after months. And one of the jurors said they should call this the United States Dairy Court because these jurors are milking it for everything they can get. And they did. Oh, they had dinners, they'd order extra food so they could take home. Sometimes they called in sick and would go to the races. They did come up with a verdict, and they awarded the mother and son $22 million. But they cost the city of Long Beach, the court system spent thousands of dollars for the feeding and care of these jurors.
Before you go, just briefly, if you could, and with the understanding that you're not actually in the courtroom, so we don't know, but based on what you know, based on what you've heard, and based on what you've read, do you think that the prosecution has proven its case beyond a reasonable doubt?
First, let me just wrap up with the jury deliberations. You asked me about that one case, the two. I described both of them in my book on page 136. So, has the case been proven beyond a reasonable doubt? Again, just based upon, and I have been following CNN's live coverage, as many updates as I can about this. So there are 34 counts. Have they proved beyond a reasonable doubt 34 counts? And again, it's about falsifying documents and with the intent to commit crimes. My belief is yes, they have proved beyond a reasonable doubt, if not all, some of, and maybe a majority of the 34 counts. And I want you to understand, before my life on the bench, I was a criminal defense attorney. I'm not a prosecutor. So I'm looking at it really coming from a defense point of view. And I believe the prosecution did carry its burden. But we'll see what the jury decides once they get the jury instructions, and how we don't know how long that's going to take.
Your Honor, Judge Cordell, always great to have you on. Thank you so much. Good to see you again.
Thank you.
The jury has stopped deliberating, but the questions are swirling around. What are they going to decide? If their late afternoon notes are offering any signal, any hint about what they might ultimately rule? Stay right here.